So, good afternoon, everyone. I am the reporter of the topic International Law. Vanessa Claire A. Carmelotes is my name. And let us now proceed to the discussion. Introducing General Principles of International Law. So, objectives. I hope in this discussion, we were able to define what is principle and what is international law. Determine what are these principles of international law, and lastly, discuss and understand the basic principles of international law. So what is principle? A basic truth or theory, an idea that forms the basis or beliefs of something. So, in law, it is a rule that has to be or usually to be followed. So, in international law, it is described as a rule of a specific, let's just say, a specific organization. So, basically, it is designed rule of that particular organization so that they have a strong bond, and that specific rule or principle, of course, is to be followed. So what is international law? It is that body of rules that govern relationship between states, functioning of international institution, organization, and rights and duties of individuals. So, international law, so this is the body of that rule or of that principle that governs relationships between states. So, it is a system of treaties and agreements. So, in general, in international law, it is a system of agreements between each nation. So, how they interact with other nations, especially to the citizens and even businesses of other nations. So overall, the principle of international law is a guide or a treaty for them to be able to be one or to be to cooperate. They have these principles that each nation has to be followed. So, the main role of international law is to promote global peace and prosperity. So the main role of international law is to promote peace and prosperity. So the declaration, so there are 7 principles of international law. Number 1 is non-use of force, peaceful settlement of international disputes, non-intervention, cooperation, self-determination, sovereign equality, and lastly, good faith. Non-use of force. International law principles embodied in customary international law as well as the United Nations Charter, which generally forbids the use of force by one nation against the other territorial or political integrity. So, non-use of force. This is a prohibited forces. Just like for example, China will attack or China attack Philippines with the use of forces or armed forces. So this non-use of force, kung for example China mo attack sa Philippines or gi-attack ang Philippines, so they already oppose or disputes or disregard this law, non-use of force, because this is the number one principle of international law. They already oppose or gilabag na nila ni nga number one principle sa international law. So, this is a prohibited forces. Kaning ipinagbabawal na forces. So, kung malabag na siya nga principle, they can say implement, pero I don't know if this is the term implement. The Article 2, Section 4 of the UN, United Nations Charter prohibits UN member states from using forces directed against the territorial integrity or political independence of another state. So, di jud na siya dapat labagon. So, the number 2 principle will further discuss or further explain why why this is a prohibited forces. So, peaceful settlement of disputes. This is a number 2 principle of international law. Peaceful settlement of international dispute is a fundamental principle of international law of a peremptory character. So, yeah, just like for example, China attacked Philippines with the uses of force, so that they can. I know that this is not the term implement, but it is a long process, a very long process. They can implement peaceful settlement among that two nations, but this is a long process. This settlement was because there was a saying that this settlement was reinforced by a moratorium on the use of force. The state's obligation is to resolve their differences by this method gained all the significance when the prohibition of the use of force, the number 1 principle, was eventually violated. So, kung ma-violate ang number 1 principle, which is the use of force, they can implement this number 2 principle, which is the peaceful settlements of international disputes, that also formulated in the UN Charter, Article 2.3, the principles of international law concerning friendly relations and cooperation among states. So, but this is a long process. This is a very long process na, not that long, but it took time. Yeah. So, number 3, non-intervention. Non-intervention. The non-intervention rule is a principle of international law that restricts the ability of outside nation to interfere with the internal affairs of another nation. So, non-intervention. So, the leader of each nation should avoid interfering in the internal affairs of foreign nations. So, kanina, number 3 principle, dapat ang leaders or the presidents or the kings of that specific country should not interfere the internal affairs, like kung naay mga problems internal in a certain country, dapat walay maghilabot na other nations, so that there is no intervention, walay oppose na principles sa international law, especially the countries that are united, that are the sangay of United Nations. So, avoiding war unless mag-avoid sila war kay syempre kung mag-interfere siya sa other nations affairs, kaya ang isang country is nag-interfere sa isa country, it could possibly cause a war. number 3 principle, para ma-avoid og war, nabutang sila ani nga principle, but kana nga kani nga principle ma-avoid ra ni siya unless kung ang war is related na sa self-defense. Like for example, nag-away ng duha ka kuan kay nahilabot ang isa. So parang isa is syempre kung tahay imong kaaway is dako gyud og mga equipment. So machines. So mahulog ka nga mag self-defense ka. So naadjay malabag nga principle kay syempre mag-avoid good kag war nya para lang sa self-defense kay ang leader nag-protect ra po siya sa iyang country. Number 4 is cooperation. The main feature of such international law of cooperation is the obligation of states to cooperate with each other. So, in international law, cooperation is based on the country's health, equity, equality, and solidarity toward other nations. So, this term of cooperation has never been defined by an international treaty, but the most important aspect of cooperation is the ethical value, which is the openness and the caring for each other's nation. So, kani grabe jud dapat na jud ni sa tanan country sa world kay kung walang cooperation is wala. Pa naman siya no, the word cooperation is easily sabotable na ba kanang ma-understand na nato dayon kay syempre cooperation even in a small group sa eskwelahan kung may activities dapat need medyo the cooperation. So ang great example of this cooperation is the United Nations. Kabalo naman tao sa United Nations. Self-determination. So, this is the number 5 I guess. So, self-determination is a core principle of international law arising from customary international law but also recognizes a general principle of law. So, general principle yun siya sa international law. So, in particular, this principle allows kani magod kay legal right of people to decide their own destiny in the international order. So kani naga-allow sa people na mag-choose sa ilahang own political status and to determine their own form of economic, cultural, and social development. So kaning self-determination is ganing principle is nag-aalaw ni siya sa mga tao nga mag-choose. They have the right to choose sa ilahang leader, president, for status, political status, and that's how the self-determination principle works. Nag-aalaw. So, number 6. Sorry kayo wala ko kuan gabi ko ko kabalo nga. November 2, wala ko kabalo na di klase. Sovereign equality. So, sovereign equality states that are the primary subject of binding international law norms. This means that all states regardlessness of their size and strength, regardless of the nature of their social, political, and economic systems, and regardless of their level of development, have an equal status in international law. So, they are equal among themselves. The idea of all sovereign are equal. So, sovereign sa each nations or states, dapat medyo equality. Because as a subject of international law or mga sangay sa international law, I don't know if this is called sangay. This is called sangay, but they have that equal rights and duties, and of course responsibilities sa in of course each country or other nations na ay na sila equality ba? Yes. So sabotable naman nung na equality sa tanan, sa labi na sa ilahang agreements kung tayo mag settle sila agreements or treaty. Dapat kung si decision sa isa, dapat sang-ayon pud ang tanan para na equality. Yes. So number 7. Number 7. The last principle, so good faith. Good faith manifests itself as pacta sunt servanda. So what is pacta sunt servanda? It is a Latin phrase which means in the international law, agreements must be kept. K-E-P-T. Di siya keep. Sure. Agreements must be kept. This was introduced and popularized by Hugo Grotius. He is a jurist and theoretician of natural law. Jurists siya and theoreticians sa natural law. So, good faith, a general principle of law, and a principle of customary international law. So, makuan tanong ka ng curious, general principle of law siya, tapos law po siya sa customary international law, which is wala na siya pariha, pero ang customary is regarding sa jurisdictions like that is reflected in several provisions of understanding. So, good faith, last na siya kay syempre, kaysa magwidi ka na ng faith. Dapat sa international agreements or sa mga each nation na agreed ang faith. Kay syempre, good faith. Kay syempre, kinahanglan man yun ni. Kay labi na sa agreements, mo siya na-manifest siya sa agreement nga pacta sunt servanda ba nga dapat ang mga agreements kay keep jud kay para ka na under siya sa good faith. Gets mo? Kanang di mo sa wala pag-explain kaning kailangan jud siya honest. Yes, honest. Dapat na ang honest, loyalty, and reasonableness. Kay kung wala na, dili na ay cause ng war or fight against different nations. So, gihimo nila kay syempre para po mahinumduman nila nga naagid niya faith sa international law. Isa gini siya ka principle sa international law. Ang honesty, loyalty, and reasonableness. So there are 4 considered as pila na ko minutes 19, my god. There are 4 considered as principle of international law. Dali natin eh. So, laches, res judicata, good faith, I just discussed earlier, good faith, impartiality of justice, judges. So, laches, it is a doctrine in equity that those who delay too long in asserting an equitable right will not be entitled to bring an action. So, laches is those country na ay agreements, pero kato siya is kanang na-delay na, tulong na kayo nang na-delay sa iyang decision. So, katong country will not be entitled to bring an action. Dili na siya i-consider na na-agree siya atong nga agreement. So, res judicata, a doctrine in Latin phrase which means a matter decided. A matter decided. A final judgment is needed to be appealed through international courts and tribunals. So, res judicata, which is a matter decided, kailangan ni siya ang mga agreements or judgment mukuan siya muagi pa siya through international courts and tribunals. Considered siya as general principle of international. So, good faith na discuss naman na. So, impartiality of judges, a decision maker, so sila ni a decision maker ensures legal processes to be fair and just. So sila tong mga judges na impartiality, kung sila ang mag-process to be fair and just sa mga agreements. So that's all. Thank you guys pagpaminaw.